Welcome to Cooper's Code, the AI show. I'm thrilled to be doing this monthly session with Shahrad Milanfar and Marshall Pohl. We're going to be talking about what's new in AI since the last time we had this episode. So with that and not much further, let's go ahead and kick it off. I wanted to turn it over to you, Marshall, because you were the one who initially surfaced the Sylvia Noland v. Land of the Free. It's a CalApp second district case. Don't think there's a citation for it yet, but the docket number is B331918 for anyone who wants to take a look. Do you want to just kind of dive in and give us a little bit of background of what happened here again?
Sure. So the case came to my attention. It was circulated by a professional group that I'm a board member of, the Association of Southern California Defense Counsel. And I'm just going to read the quote.
The quote is outstanding because it just kind of sends a message that people seem to still not quite learn.
Right. And then we can talk about some craziness beyond that. But so here's what the Court of Appeals said, which is as follows. The quote, "What sets this appeal apart and the reason we have elected to publish this opinion is that nearly all of the legal quotations in plaintiff's opening brief and many of the quotations in plaintiff's reply brief are fabricated. That is, the quotes plaintiff attributes to published cases do not appear in those cases or anywhere else. Further, many of the cases plaintiff cites do not discuss the topics for which they are cited, and a few of these cases do not exist at all. These fabricated legal authorities were created by generative artificial intelligence tools that plaintiff's counsel used to draft his appellate briefs. The AI tools create fake legal authority, sometimes referred to as AI hallucinations, that were undetected by plaintiff's counsel because he did not read the cases the AI tools cited." And then what the Court of Appeal did was it sanctioned $10,000 to be paid by the attorneys to the court. And the court did not impose the sanctions, which would have been paid to opposing counsel or the opposing party's fees, because a declaration was not filed detailing those. But what it also did was it directed the clerk of the court to send the published decision to the state bar for reporting. And I assume that those lawyers are in the process of getting into a fair amount of trouble. And so for me, what's just unbelievable is this court took an opinion that by all accounts would never have been published. There was nothing new about it, not a new issue of law, nothing undecided. They just published an opinion to show what this person did and how bad it is. And so now, to my knowledge, this is the first published opinion where you've got a court basically chastising and sanctioning counsel for using fabricated and hallucinated AI cases, which obviously is something we've talked about here. And what we were talking about a little offline, to me, it's just astonishing. Despite all the articles that exist online and in print of lawyers doing this, right, falling into this trap, where perhaps earlier they may have been able to claim some sort of innocence by way of naivete. Now it's everywhere, but yet these lawyers are still doing it. And in an arbitration I had, our opposing counsel did it, and he got burned. And I just find it fascinating that the word has not reached all these lawyers to just not do this type of thing.
It brings up something for me, and that is, I am mindful that the people who we tend to associate with are people who tend to stay current. What I mean by that is, Marshall, I met you at an ATC presentation. Shahrad, we got to each other through the greater legal community. I think actually I may have seen you presenting at What's New in Tort and Trial.
We were both attending, I think, but yes, that's where we met. And that's exactly what your point is.
Exactly. So I think that there are a lot of lawyers, the type of lawyers who listen to a podcast like this, who stay current. I also think that there are a large number of lawyers who unfortunately probably become your clients at some point, Marshall, for the legal mal defense or state bar issues that they're facing, who don't do these kinds of things. And I've come across lawyers who don't even have have a Westlaw or any sort of, whether it's Lexis, Westlaw, or one of the other also RANs, don't have access to that. And so while it is, I think, surprising at an appellate level for someone who could get so checked like this, I think we'll see more of it.
Actually, I recently tried a case. My opposing counsel didn't own a cell phone. And, nicest guy in the world, tried a great case, just a pleasure to deal with. But I just thought that was fascinating to me, because there were a couple times I learned it because the court was trying to reach him because he was late and we couldn't do it because he doesn't have a cell phone. And, so I agree that there's just a lot of lawyers who don't have the access that we are privileged to have and have the professional networks that we all have, that we think it's just commonplace. And I guess maybe I certainly take for granted the fact that it's so easy to find this stuff out, because that opinion was sent to me, by an organization I'm involved with, so easy for me to say, oh, it was right at my fingertips, when I otherwise, certainly would not have seen it absent it being published in perhaps some other way, or I might have missed it altogether. So, I get it.
Well, and I'm not excusing a lack of knowledge. I think, Shahrad, you're the one who, one of our presentations brought forward the duty of competence under the, and I don't have the citation at my fingertips, probably because
Rule 1.1.
1.1. Yeah.
See, I lack the competence there. But the idea that we are supposed to stay competent, and yet at the same time, when you're running a busy practice, it is challenging, I think, to stay on top of every single thing that is happening out there.
Let me just pose this question. How many of us have heard the words, "I'm not a technology person"? This is a common retort by lawyers all the time. Well, I don't know about that. I'm not a technology person. Well, the rules require you to be a technology person. And how do you become a technology person is by checking things out, trying things out and figuring out what works best for your practice and your approach. I've been trying cases using an iPad since 2014. And people would look at me like I was crazy when I would suggest that. Oh, we've done this with pen and paper. We use butcher paper in our trials. We don't do this fancy technology stuff. Okay, great. You bring your butcher paper. I'll bring high resolution images on an iPad, and let's see what the jurors pay attention to, right? But this is, I think, a constant battle in our field with people who either refuse to use the technology or rush in headlong and don't understand what they're doing without doing a little bit of due diligence because they want to just get it done and move to the next thing, but because they don't want to be bothered by it.
I'm not sure which is more challenging, the ones who rush in and don't understand what they're doing, or the ones who almost take pride in the Luddite approach. I will say, I am somebody who likes butcher block. I think switching the modalities up in trial, I'm not going to be on butcher block the whole time, but when you have an expert create something, point by point in front of the jury and mark it, it may not go into the jury room, but when you reference that in closing argument, the juror's like, oh, I saw that thing get built. So sometimes that can be, I think, a useful tool, but it's got to be a tool in a toolbox, not the only thing you're going to.
Yeah, I think it's like the fluidity, like you say. I mean, you got to be able to do everything. And I think the people who are falling into these pitfalls of just using it and not checking it are the people who are like, yes, my job just got a lot easier, and that's, I think, the problem that's existing. And I'm sure there's people doing it right now, and briefs being filed and motions being filed right now that unfortunately are falling into this. And, I bet it also, just, I'm totally speculating, but just runs the spectrum of first year lawyers to 55-year, 60-year lawyers. It's because I think people just look at it like they don't have, it makes their life so much easier and they can do so much more.
And the irony of it is it does, and you can. It's just, if you use it effectively and efficiently, it can be that much more useful than just going in headlong and then having to face something like these lawyers did in this appellate case. And look, we're all human. We all make mistakes. But looking at it, it was not only in the opening, but the reply brief. I mean, I can forgive the opening brief. You made a mistake, something got by. But also in the reply brief, it just says, I was mailing this thing in. And again, maybe I'm a little too paranoid, but mailing in an appeal is a pretty serious issue in my book.
Yeah, the referees have a lot of power. It's not like we're sending this in to a corporate board that there's some memo that's got wrong, erroneous information, and maybe someone gets a slap on the wrist, maybe someone gets fired. This gets reported. There's monetary sanctions, as we know, and then obviously state bar issues that come into play. So there's real consequences with respect to the people who are overseeing what we're doing, rightfully so.
Going back to, and there's whether it's the ABA or other entities that have come out with model rules on how to engage with AI. I think that California Rules of Court also recently had one. I think I kind of boil it down to, if you're signing it, you own it, as a summary of what the rule is. And I know you, Shahrad, and I believe you, Marshall, also use some AI tools in assembly. So if somebody here who is thinking of using AI, but is not sure how to do the best quality assurance on the if you sign it, you own it front, what methods do you have to double check things to make sure that what's going out actually is what it purports to be?
So, Miles, before we jump into that, it is the Rule of Professional Conduct 1.1, and it's footnote 1 that talks about technology.
You're going to get our ethics credit for the MCLE for this episode with all your citations.
Nothing brings viewers like citing the rules of professional conduct.
You'll see the uptick in this moment of the podcast.
Yeah.
I mean, one thing I have started to do for other firms, and I've recommended that they do this in seminars that I give, is to create a policy within the firm of if you're going to allow it, and if so, when it's going to be used, who can use it, and how it can be used. So that way, at least if something does happen, right? If you have a larger firm and you have newer associates, unless you block specific sites, which obviously you can do, but they can easily access them from personal computers. So, and again, I don't think, blocking and not using AI I don't think that's the right approach here. So I think it's using it, but clearly identifying, again, how and when it can be used, so that at least you have that framework so everyone understands. And then from there, it's training, right? You've got to train, if you're having younger associates do it, you've got to train them on what they can do and how they can do it, and who they can provide the information to, and then confirm that it's been checked, et cetera. So if you use that as the starting point, as I've recommended, and I've reviewed a lot of firms' policies, and there's firms approach it very different ways. And I appreciate the differences and concerns that each and every one of them have, because they dramatically differ from practice type to size of firm to age of the lawyers. They're all different concerns. And so they address them. There's no one size fits all policy. And so from there, I think that you can add value for your clients. And I mean, I have on my other screen right now all day, I've probably got 15 Westlaw tabs open and then 3 different AI platforms open, because I'm bouncing back and forth between themes of a case I got coming up for trial and then legal issues. And then once I get them through Westlaw, I'm plugging them into AI to get additional information and sort of streamline arguments. And so I'm just constantly going back and forth, which is amazing. And if I was just using Westlaw, I would not be as efficient as I have been today with respect to the work that I'm providing on behalf of my client. And nothing I've done is going to result in a fabricated legal issue. I'm not submitting anything to the court. Everything I'm doing is for my own information, but nothing is incorrect because it's all been verified, and I'm doing it diligently. If I was, just on Westlaw, that's a little old fashioned. I think I'm hampering my efforts. If I'm just on AI, I think I'm a little too risky. So that's literally my screen right here is what I'm looking at.
I mean, obviously, having a policy now. We've had some new people that have come on board, so we're working on a written policy because my approach was to talk directly to our folks about what to do and what not to do. So we're having to change that a little bit at this point. But having a policy, I think, is a great idea. Also, knowing what tools to use for what task. Because if you're looking for case law citation, right, maybe going to ChatGPT or Claude is not the best approach. Maybe you want to go to Westlaw and get that silo to do the work for you. Or if you get something from ChatGPT, take that citation and dump it into Westlaw and see, all right, is this a legitimate citation? I've actually done this with discovery responses that we got and said, well, give me the strength and weaknesses and tell me whether or not there is any case law that supports this. And to my surprise, Claude was able to give me a research memo and it gave me 3 cases on a premises liability case. I knew 2 of them, so that was encouraging. The third one I wasn't familiar with, so I took it and I put it in Westlaw and vetted it, and it was legitimate. So that's the way you look at it, as opposed to saying, oh, here are 3 cases. That third case could very well have been a hallucination and it could have gotten by me if I hadn't taken that extra step. So what Marshall is doing is spot on in terms of making sure that you're using different platforms to vet the work and the information that you're getting. And having talked to some folks who work in AI, that's exactly what they say that they do in their approach, is not just take wholesale what somebody says. Just like if we talk about a case, maybe I'll run it by another attorney just to see what the other point of view is. It's really not that different. But the reality of it is, from our point of view, if we're looking at all this stuff and we're saying this is great, you can't have the expectation that when you put the information in there that the end product is going to be perfect. And I think that's what's getting people into trouble, is not remembering dial-up, right? When you had to connect to the internet. Now, if that web page doesn't load within a millisecond, you're going, my God, why is it so slow? When in reality, if you go back to when dial-up was a thing, it really was not something where we would sit there and be like, oh, it didn't load in a millisecond. It may take a minute for it to load. So now we just have to readjust our expectations and, fight our own lazy tendencies.
I don't think it's made me do anything faster. I don't think I have sped up having implemented AI tools that I use, I'm not completing a task quicker. What I'm doing is I think it's expanding my thought process and how I approach things, and allowing me to sort of open up a whole new avenue of allowing me to think about different things and synthesize those thoughts in a different way. So I don't think, like today, what I've been working on, if I didn't have AI, I don't think it would have taken me longer. I think I've just been able to look at more things and just tackle different issues than I otherwise maybe have not thought of. So it's sort of opened more doors for me. So I suppose I'm looking at more information in perhaps the same amount of time, but it's not like I'm sitting here being like, oh, now because of AI, I accomplished the task in 1 hour when it would have taken me otherwise 3 hours. I'm still spending all day on what I've been doing. It's just another way of adding value.
But that's the difference between your mentality of seeing this as a tool to enhance your abilities, your skills and training, as opposed to using it as a crutch so that you can go sit on your porch and have a drink at the end of the day, right? So there is that approach, because you're looking at it as something that, hey, this can make me better, as opposed to, well, this can just get me to get away from this and not have to deal with it.
I would say your 2 approaches are very different from mine. I got 3 appellate briefs done this morning and spent the rest of the day surfing.
And, I think that's amazing. And I hope the waves were great. But Miles, there's a lot of firms who are doing that. And we've probably touched on this, but, on the plaintiff side, you don't get paid by the hour. And so there's the incentive to do that. And I
Yeah.
think that is dangerous. There's less of an incentive for me to do it, even if I wanted to. But on your side, the more time you spend on your case, the return on that investment just goes down, down, down. So I just think on the plaintiff side, there's a lot more appetite to just have it be done so you can be on the beach surfing.
Each side, whether you're a billable hour or a contingent fee, there's a pro and a con to the approach. And there is a subconscious bias that you need to, I think of that on the contingent fee side. We make sure, as I'm sure, Shahrad, you do with your clients and the people that you work with, we don't care if it's 10 hours or thousands of hours into a case. The case is going to get the same attention. And some of them we make more per hour, and some of them we make less than minimum wage. And such is life. And in the long run, it all evens out.
That's an important point in the sense that the model that your firm runs and my firm runs is very different than volume firms who are just churning cases in and out. And that same case is being settled for a fraction of the amount that you or I can get for the same client. So the incentive for those firms may be very different in terms of, all right, let's just get it in, get it out, get a demand letter, whatever they want to throw at us, maybe we'll take, as opposed to, no, I'm going to work this up and get a better result for the client.
There clearly are, and I've spoken to some people who have done what you jokingly said, Miles, which was create a brief in 20 minutes and gone to the beach and gone surfing. And guess what? The brief was perfectly fine. It's not to say that every time you do this, you're going to get fabricated and hallucinated cases. If it's a pretty straightforward issue, and certainly if you know the cases, that once you see them, right, which it's happened to me a lot of times, Shahrad, you just mentioned you do 2 of those cases, boom, you're done. And so it can be really helpful. And I'm sure hundreds and hundreds of briefs have been filed based upon just 100% AI generated with accurate case law and very thoughtful and thorough analysis, and probably have prevailed. And those lawyers are sitting on the beach with a big smile on their face. And that's great. I think it's, risky, but if they did it responsibly, I'm not going to sit here and say that you shouldn't have done that, because they know, no, Marshall, I knew the cases, the analysis was good, I checked it, and I was out of there. Good for you. That is what AI can offer. But that lawyer is a very intelligent lawyer and still being responsible because he or she has a deep knowledge of the law in their particular field.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts, and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. I'm going to pivot now to Shahrad. You submitted for our discussion Nvidia's $100 billion investment in OpenAI. And I thought this was going one direction, and then you clarified for me its utility in another way. So do you mind unpacking that for us?
Sure. So in the last week and a half or so, we've seen Nvidia announce that it's investing $100 billion with a B into OpenAI. Microsoft's investment in OpenAI is reported to have gone from $13 billion in value in terms of what they invested, is now worth $150 billion. And we've seen Larry Ellison's net worth in one day jump by $100 billion. So a lot of defense firms and insurance carriers are complaining, right, about these nuclear and thermonuclear verdicts. This is ridiculous. Why is this happening? Well, when we look at this, if the jurors are exposed to these kinds of numbers and seeing the kind of money that's being thrown around, when a plaintiff stands up and says, hey, award my client 30 or 40 million dollars, the jurors psychologically, in my opinion, are not seeing those numbers be as large as they would have been thought to be in the 80s or 70s or 90s. So it is a very different dynamic and atmosphere. And there was a sex abuse case in Los Angeles where the jury awarded $114 million in that case just recently. So when you see those numbers, as a defense firm, you have to ask yourself, all right, when I'm sitting there saying, no, this case is not worth anything, that the medicals are not there, the real risk is that if the jury is willing to award large numbers on non-economic damages, it could end up being a massive verdict, which is what we're seeing significant increase since 2020 in those cases.
Shahrad, I fully expect that the next opposing counsel who you go to trial against, who is doing their due diligence, will be filing a motion in limine on referencing Nvidia and OpenAI and investments.
And Reptile.
Reptile, of course, yeah. No Reptile.
What is that? You guys don't even know what that is. You've never heard of Reptile. I love getting the opposition to that MIL. I don't even know what that is.
I will say, this is a little bit of a tangent, but the last time we opposed it, we acknowledged its existence and said that is so far back in the iterations of development that is now referred to as the dinosaur theory. We've got our new things. So
I'll bet if I look hard enough at the books behind you, Miles, I might see the Reptile theory book somewhere.
Yeah. I don't actually have that one. So I think the only one you can really make out is Dune, which I do not use for legal argument very often. But you have a copy.
I didn't have to go far.
Yeah. Well played. Well played. Joking aside, do you have thoughts on that as in terms of dealing with it on the other side? Because I know that some of the work that you do is defense, and some of it is defense where people are asking for money. If someone were to use that as an argument for, it's not a lot of money, just look at this, that, or the other.
I think that these types of analogies are pretty commonplace, whether people show jet airplane, fighter airplanes, the Monet, right? From your classic cases in closing argument to anchor these jurors is nothing new. I think the difference, what is new, is the dollar figure and the numbness that we have to big numbers, with not just Larry Ellison, with all those super, super wealthy people. And also, I think with social media and the ability to see how they live and how it looks so easy to get a big yacht and get a few jets. And so I think from a societal standpoint, jurors don't view those numbers as, oh my gosh, they're huge. Like you said, mentioned the $114 million verdict last week or the week before in LA Superior Court. I mean, that lawyer's gotten a few of those to my knowledge. So he knows how to do it, and good for him. I just think it's more a numbness that everyday people have to those big numbers, and the willing to understand that injuries can and perhaps should result in an award of a substantial number like that. I think it's on the defense side, and I'm 95% of the time on the defense side. It's our job to be as creative as the plaintiff side is in coming up with ways to, negate all that. With the fighter jet example, I always laughed because if the fighter pilot who was in that jet died, the federal government has a set limit on what that person's life is worth, and it's not a lot of money. And so anytime that reference has been made, it certainly opens the door to say that I think at the time, last time I remember bringing it up, it was like $180,000 or something that the family got. And so, when you're valuing a life, well, the federal government certainly values it, and it's not a 7-figure number. So it's things like that keep it fun and entertaining.
It's chess, not checkers. Yeah. Well, switching gears a little bit, I did want to bring forward, I was playing around with Claude over the past, I think it's been within the past 2 weeks that a couple of new things got unlocked. And one is that Claude, if you toggle a button, can now access all one's past chats. And it used to be Claude could only work in the chat that you had in the moment. But now, if you have a subscription, it can look at all of the prior chats and use that to inform its discussions going forward. And the second one is its apps. It can interface with apps and create Word and Excel files. And the third that just showed up, I think, on Friday was it can schedule, meaning it can, if you allow it, it can access your calendar and add to your schedule, but it can't delete. So if it adds something, it can't delete it and it can't move things. I bring these forward in part because this is a long entry to our conversation, but it seems like just 2 months ago that Anthropic was talking about a research exercise that it did in a sandboxed environment where it allowed an AI to go into a sandboxed environment, work in the server where there was information in various emails about, and I'm going to overly simplify this, but in essence, one of the people who had the power to pull the plug on the AI, the IT person, had emails that indicated that he was having an affair. And in that study, the AI threatened to blackmail the IT person if the IT person shut it down. So, but my springboard here is I find it interesting that these were issues a couple months ago, and now it's starting to make its foray out into the world. So that's a springboard for you, Shahrad, Marshall, in terms of, are you using these tools? What do you think about them? Do you recommend people play with them? Not, and go.
So I'm only allowing the chatbot to blackmail my hologram. So that's one safeguard.
Okay.
But the other piece of it is that when you look at these things, the chats are supposed to be, if you have the premium version, are supposed to be in their own silo. So if it's accessing it, and I believe the last time I looked, when you delete a chat from Anthropic, it basically gets deleted out of their system within 30 days of you hitting delete. So unless they've changed that policy, and I'm not sure if they have, that was the policy before. And now they have it so that it can generate Word and Excel documents. And I have not used that feature yet. And frankly, at this point, I'm not inclined to give anybody access to my calendar. So that hasn't been an issue. But the Word and Excel documents seem to be useful because before, when you would download the chat, if you asked it to generate something, it would be in a format that basically you had to play with in order to open, and it had all these weird codes in it. And now I think they're trying to solve that issue.
Yeah, for me, it's playing with each of them. I agree regarding the calendar issue. Some things I like to wait a little bit until I'm just going to give access to my Outlook, which is for me by far and the most important program I use is Outlook. But I think it's trying all these different things out and trying them in different ways. I also agree regarding like the Word and Excel files. I've noticed when I've tried to migrate things from Word to Excel, there's sometimes it's not quite seamless or as seamless as I want it to be. And I think it's just getting better and better as you go to do that. As far as saving chats, that's not something I generally have looked at it starting fresh each time. I haven't had sort of this continuing and ongoing conversation really day by day, but I think that that's super helpful because you can just build on it. And I really like calling it a conversation because you can get tired and you can say, let's pick this up tomorrow where we left off. And you can just do it. And it remembers exactly all the points that were discussed, all the nuances, and you can just keep going from there. So it's just really just such a great extension in the human perspective and how we interact without the memory lapse of real life humans that's going to occur.
One other thing to keep in mind is that Copilot, if you use Outlook, there's now a button at the top right corner that says Copilot, and you can use that, and then it gives you, they have options like prompt coach, writing coach, idea coach, career coach, learning coach. So those are all things that are being rolled out, and I haven't had a chance to look at them in any detail, but they're now putting Copilot into our Outlook, which could or could not be problematic depending on, how you look at it. But that's another thing that's coming out. And I know Westlaw's co-counsel also has a plugin that you could put in where it can help with email writing and that sort of thing as well.
Full honesty, I just clicked the Copilot button for the first time as I'm sitting right here.
I have played a little bit with Copilot, and one of the things, if you have a large body of email communication, it will start trying to mimic you and offer drafts in your style. So, but it's still, it looks like it's pretending to be you instead of being you. If you read the content,
I feel like I'm still pretending to just be me. So probably pretty good.
So far, you've been doing a very good job. And the conclusion of this will tell everyone that this entire podcast is actually Google LM using our avatars, right?
Well, I'm pretty sure you have a claim against them because the voice is remarkably similar to yours. So maybe that's an angle that we could take.
Maybe I should be looking to somebody for IP representation as far as I would say on the Copilot side, and this is something that I would hope to see, and maybe there are people who have played around with this more. My schedule is always a game of Tetris. And so if Copilot reached the point where it could start suggesting time blocks and moving things around and getting to know my schedule and offer improvements on how I do my work, that would be huge.
I think that would be amazing to just see how you can be more efficient with managing your inbox and things like that. That's a whole area for me that would be such a stress reliever, because for me it's the emails in the night and things like that that keep me up, and the scheduling and remembering if you did things. And I'm sure there are so many gaps in my efficiency, even with assistance and physical human assistance and things like that. So I'm going to dive into this and report back for next episode.
Well, I know, Shahrad, we were going to talk about Google Notebook, but I think we're getting close on as far as time for our recording window for this. So I think we'll put a pin in that, save it for next time, tease a little bit in terms of that. For anyone who's listening, if you have found some cool new stuff, want to share, drop it in the comments, send us an email at podcast@coopers.law. And as always, for all of you doing justice out there, happy hunting.